Good afternoon. I'm Robert White, council member at large and chair of the Committee on Housing. Today is Tuesday, October 8th, 2024, and we're meeting in room 500 of the John A. Wilson Building remotely via Zoom. The time is now 4:14 p.m., and I'm calling to order this additional committee meeting. We have a quorum consisting of myself, Council Chairman Phil Mendelson, and Ward 5 Council Member Zachary Parker. Today, I'm putting 3 confirmation resolutions and 1 permanent bill before the committee. Four proposed resolutions, and I'm going to update this. Apologies, I had an outdated draft of my statement. All right, my apologies. First, today we will be considering the Committee on Housing Cape Conquest Staff Appointment Resolution of 2024, which will formally appoint Kate Conquest to join the staff of the Committee on Housing. Kate has been working with us over the recess and is quickly getting up to speed on Department of Human Services issues. She has already been contributing to our office in meaningful ways and recently drafted her first legislation. Kate comes to us with significant experience in public policy at City Health, where she worked with lawmakers across cities and worked to develop advocacy coalitions on health policy. Kate began her career as a social worker, which provides unique insights into the work of this committee, and holds a master's of public policy and law and a bachelor's of arts in sociology. I couldn't be more proud to put forward Kate Conquest for formal appointment as staff for the Committee on Housing. Is there discussion on the Committee on Housing Kate Conquest Staff Appointment Resolution of 2024? Hearing none, I move the committee print for the Committee on Housing Kate Conquest Staff Appointment Resolution of 2024 with leave for staff to make technical and conforming changes. All those in favor, please say aye.
Aye.
All those opposed say nay. In the opinion of the chair, that's a unanimous yes vote. And the resolution passes. The motion passes. The 3 proposed resolutions before us for markup would reappoint members of the Rental Housing and Real Estate Commissions. Commission appointees play a key role in implementing our laws and policies. By acting as liaisons between industry and government, appointees make sure policies work in practice. They also carry out and interpret district laws. It is crucial that we have the right people in place to do this important work, and it is crucial that we review their qualifications diligently. I take this responsibility seriously. After hearing from the nominees at a roundtable on September 19th, I am happy to support the 3 nominees in front of us today. First is PR 25-822, which would reappoint Toya Carmichael as an administrative judge on the Rental Housing Commission for a term to end on July 18th, 2027. Without council action, the resolution for her appointment would be deemed disapproved on November 10th, 2024. Judge Carmichael has the skill set, knowledge, and commitment to public service to effectively serve on the Rental Housing Commission. Throughout her career, Judge Carmichael has drafted judicial decisions, conducted mediations, and advised on areas such as ethical and legal obligations. During her first year and a half on the commission, Judge Carmichael contributed to the commission's goal of completing cases on a shorter timeline and issued 12 orders and at least 1 decision. by actively partnering with other agencies, including the Commission on Human Rights and the Department of Housing and Community Development. Judge Carmichael has demonstrated her desire to make government systems function well. She shared she is committed to supporting residents by producing legally sound, compassionate, and concisely written decisions and orders. Judge Carmichael's dedication to service has earned her several awards, both locally and nationally, including the National Bar Association's President's Award this year and the Washington Bar Association's Young Lawyer of the Year Award in 2016. Based on her qualifications and statements during the roundtable, I will be supporting Judge Carmichael's reappointment today. Is there discussion on PR 25-822? Hearing none, I move the committee print and report for PR 25-822, the Rental Housing Commission Toya Carmichael Confirmation Resolution of 2024, with leave for staff to make technical and conforming changes. All those in favor, please say aye. Aye.
Aye.
All those opposed indicate by saying nay. The ayes have it, and the motion passes. The second resolution for markup is PR 25-914, which would reappoint Erica Black to the Real Estate Commission as a commissioner with a real estate salesperson license. If reappointed, Ms. Black's term would end on December 13th, 2027. Without council action, this resolution would be deemed approved on October 24th, 2024. Ms. Black is an accomplished residential and commercial realtor with over a decade of experience, consistently ranking among the top 15% of agents worldwide. With expertise in marketing, negotiation, and communication, she excels in guiding both buyers and sellers through successful transactions. Her professional achievements include being recognized as Coldwell Banker's Rising Star and as a member of the International Sterling Society. In addition to her real estate career, Ms. Black has demonstrated strong civic engagement. She previously served as a commissioner for Advisory Neighborhood Commission 7D, where her advocacy focused on economic development, beautification, and neighborhood safety. She holds a master's in public administration from North Carolina Central University, and her commitment to public policy, community development, and service is evident in her volunteer work and leadership. At the roundtable, Ms. Black expressed deep gratitude for her role on the District of Columbia's Real Estate Commission, where she has served since 2019. She shared how her passion for real estate began with the purchase of her first home as a college student. Her purchase sparked her commitment to helping others achieve financial empowerment through home ownership. As a commissioner, she is dedicated to engaging students in the real estate field and promoting service as a core value. Ms. Black also highlighted her industry success, including being named the #1 agent in Washington, D.C., and reaffirmed her dedication to regulating licensees, protecting the public, and expanding access to real estate opportunities. Is there a discussion on PR 25-914? Hearing none, I move the committee print and report for PR 25-914, the Real Estate Commission Erica Black Confirmation Resolution of 2024, with leave for staff to make technical and conforming changes. All those in favor, please say aye.
Aye.
All opposed, say nay. The ayes have it, and the motion passes. The third measure for markup is PR 25-915, which would reappoint Edward Downs to the Real Estate Commission as a commissioner with a real estate broker license. If reappointed, his term would end on December 13th, 2027. The resolution will be deemed approved on October 24th, 2024. Edward Downs is a highly experienced residential real estate professional and has been licensed in the DC, Maryland, and Virginia, Maryland, and Virginia since 1990. He actively manages the listing, marketing, and sale of residential properties and serves as a buyer broker for clients. Alongside his real estate practice, Mr. Downs mentors new agents and provides support to experienced colleagues. At the national level, he has contributed to several committees with the National Association of Realtors and earned the distinction of Realtor of the Year for the District of Columbia in 2013. Locally, Mr. Downs has led the DC Association of Realtors as president and taken on leadership roles with the Greater Capital Area Association of Realtors. During the roundtable, Mr. Downs shared that he is a second-generation Washingtonian, a DC property owner for 43 years, and has practiced real estate for 34 years. He highlighted his 19 years of volunteer work within the real estate community, including leadership roles at the local, state, and national levels, and his 6 years of service on the DC Real Estate Commission. His extensive experience, coupled with his involvement in the Association of Real Estate License Law Officials, equips him with a unique perspective on public safety and fair treatment within the real estate industry. Mr. Downs recommended specific improvements for the DC Real Estate Commission, such as developing a comprehensive license management system, creating a searchable database for complaints, mandating training for all commissioners, and updating regulations to enable quicker responses to public and licensee concerns. Is there a discussion on PR 25-915? Hearing none, I move the committee print and report for PR 25-915, the Real Estate Commission, Edward Downs Confirmation Resolution of 2024, with leave for staff to make technical and conforming changes. All those in favor, please indicate by saying aye.
Aye.
All opposed, say nay. The ayes have it, and the motion passes. We will finish with Bill 25-49, the Local Rent Supplement Program Eligibility Amendment Act of 2024, which comes to us from Chairman Mendelson. This is a permanent version of legislation that we've had in place for several years now on an emergency and temporary basis. However, the committee print reflects some changes based on feedback we received at our hearing last year and in the months since. The bill deals with the Local Rent Supplement Program, or LRSP, which is our locally funded housing voucher program. LRSP is a lot like the Federal Housing Choice Voucher Program, and both programs are administered by the DC Housing Authority. DCHA has to follow federal rules for federal vouchers, and unfortunately, that includes some pretty draconian rules that don't track DC values. Luckily, we're allowed to set our own local rules for local vouchers. Federal vouchers aren't available to people with certain criminal histories, but Chairman Mendelson's emergency bills have made it so DCHA can never consider arrests, convictions, or ongoing criminal matters for any reason, including initial voucher eligibility or later termination. That's generally the right approach. Returning citizens need support to reintegrate into our communities. Now, this bill doesn't change what landlords can consider. It's just about DCHA. Landlords have opportunities to conduct tenant screening based on criminal records under a separate law. But if a landlord is willing to accept a tenant, criminal backgrounds and all, then we shouldn't let the lack of a voucher pose a barrier. The committee print amends the bill with a narrow exception for situations where someone is reported to be actively creating unsafe conditions for other residents through criminal conduct. DCHA has told us that if they can't credibly threaten to withdraw someone's local voucher, then they can't play any role in addressing unsafe situations, and that can lead to very toxic situations in a neighborhood. The print would still prevent DCHA from relying on just arrest records and no other evidence, and it would task DCHA with trying to connect people with other local supports if it does take the extreme step of removing them from LRSP. Chairman Mendelson's emergency bills have also lessened documentation requirements for LRSP participants compared to people with federal vouchers. Local voucher applicants can self-certify anything for which they can't easily get documentation. Lowering barriers to voucher access is important, but DCHA says the emergency bills have led to occasional incoherent results, like where someone certifies they have zero income, and then other databases show that they have pay stubs, and DCHA has no authority to try to resolve the discrepancy. The committee print also makes clear that DCHA is allowed to check for information on their own before opening up to self-certification, and to set up a process for resolving inconsistent documentation and self-certification results. DCHA has also asked for the right to demand IDs later in the process after the initial eligibility stage is done. Their hearing testimony suggested that the 2-year recertification point would be an appropriate time to require ID. I'm nervous anytime someone says that poor people are committing fraud without specific evidence, but it's also in the people's best interest to go ahead and obtain ID if possible. So the committee print directs DCHA to try to and refer people to service providers who can help them get an ID. Then at recertification, DCHA may insist on ID, but has the discretion not to. Is there discussion on Bill 25-49? Chairman Mendelson.
Thank you, Chairman White. So yes, of course, I'm going to support this bill. It's a bill that I introduced, as you noted. The reason why I want to speak to it is because members will recall that we have adopted this legislation in I think 3 iterations or not iterations, the bill's been largely the same. At 3 different times as an emergency and temporary. It's been in effect for a couple of years, so we have experience. And last year, the Committee on Housing had a hearing on this bill before us, 25-49. As we know, the mayor with the last version, not the second or the first, vetoed the legislation and the council overrode the veto. And it very much concerns me, the criticism that the mayor made, because some members of the public picked up on that as if she was correct. She alleged that the bill should not be adopted because there was fraud. No evidence of that. At the hearing that the Housing Committee had last year, and the Housing Authority testified, they didn't say there'd been fraud as a result. So with all due respect to the mayor, she basically made that up when she said that was the basis for her veto. I believe she also said that it was too expensive, even though we have fiscal impact statements that indicate it's not, doesn't create a greater cost, this bill. And so I want to be clear about that for the record as we mark this up, and if you could include some of this in the committee report. That the reasons that the mayor gave just simply are not borne out by either the experience of the last couple of years or by the testimony by the Housing Authority, who's primarily responsible for these vouchers. As I recall, DHCD, the mayor's subordinate agency, also testified at the committee's hearing last year. They didn't raise the concerns that the mayor raised in her veto letter. Now, there also have been some upset from residents, homeowners, or maybe not just homeowners in the community, some of whom live along the Connecticut Avenue corridor, because there's been, shall we say, an abundance of voucher holders who are living in apartments there. And there's been some controversy about that. But the criticism that I heard was that this is just unbelievable that we would allow tenants to self-certify and then move into these apartments. Well, it doesn't work that way. This bill is about getting vouchers. It's not about getting units. Now, I realize you don't get a unit if you don't get a voucher, but they're two different decisions, and they're decisions made by different parties. So if a neighbor is upset because the landlord of an apartment building is allowing all kinds of people to live in their building, and as I'm saying that, I'm thinking to myself, that's not really appropriate, but if the neighbors are upset, they have the landlord to blame, not the city. All this bill is about is whether somebody typically homeless has a right to try to apply for a voucher for housing assistance. That's all this bill is about. I would further like to note that with regard to the issue of self-certification, the applicants for vouchers almost always are homeless individuals. And so they're not going to exactly have the kind of identification, and certainly not the proof of residence, as in this is my address, that somebody who's housed would have. So we're dealing with a clientele where self-certification makes sense. Chairman White, you noted that the committee print has some guardrails and some ability for the Housing Authority to look further. But there's a reason why this bill is allowing for self-certification, because of the uniqueness of the clientele. This bill is not about overwhelming any building or neighborhood or any place, because that's by the decision of the landlord, not simply getting a voucher. And it's simply not correct that there's been a fraud and that this bill is very expensive. So I wanted to put that on the record, just so it's clear. Thank you.
Thank you, Chairman Mendelson. Councilmember Parker.
Thank you, Chair White. I too just want to raise two issues that I know I spoke about with your team, but for the public record, I think it's important. First, I would just say we ought to be reducing as many barriers as possible to get more people into housing. And that is true for returning citizens and all neighbors. Two areas of concern that are top of mind for me, given the council's recent action on the ERAP program in particular. I heard from housing providers that their hands are tied, or they're feeling as though their hands are tied in some ways around security, because they are prohibited for screening individuals. And this is some might suggest creating scenarios, not necessarily just focused on returning citizens, but where individuals are in complexes, in homes, and we've also heard similar things with DCHA, just around the lack of a stopgap measure in the process to ensure there's safety in these premises. I wanted to just raise this question to invite you to speak to Chair around like the avenues for DCHA to in fact screen. So I was talking with your team. It is my understanding that DCHA can, after an individual has submitted an application, screen for certain crimes and take certain steps. So if you could speak to that. And then the second is actually what the chairman was touching on, this self-attestation component here, which I know has gotten a lot of attention both here, but also given what we were focused on for ERAP. And it is my understanding here, as the chairman suggested, that this committee markup in print gives DCHA added tools to verify and certify, if you will, what an individual is self-attesting to. So if you could speak to that, those are two concerns that I think have been bubbling up in the public. And I just want the public to know that as we're moving forward here, these matters are being addressed in this committee print. Thank you.
Thank you very much, Councilmember Parker. We want to make sure that we don't have any unreasonable burdens, but we want to make sure we take a reasonable approach, particularly given health and safety concerns that have been raised, but also just limited financial resources for the city. So with respect to the DC Housing Authority, they can, if they discover information, for instance, if someone self-certifies that they have no income, and then DHS's records show that they submit pay stubs, well, that seems to contradict. So the Housing Authority can address the issue and question the self-certification there. They also may require IDs at the recertification stage. So that's 2 years in, if someone's self-certified to their identification. And they will assist people in getting IDs as well and get them to the right directions and resources. In addition, while DCHA cannot prohibit, cannot deny a voucher based on crimes, landlords can. And so this bill does not put any additional restrictions on landlords. So if they want to do criminal screenings within DC law, they may do that. So there are some checks and balances that I think are reasonable, but address concerns that both agencies and residents have raised with us.
Thank you.
Thank you very much, Councilmember Parker. And to Chairman Middleton's point as well, and it's for residents because there are very real health and safety issues being raised by some residents that, you know, are attributed to people who have vouchers or people who think have vouchers. Either way, the issue is not about the voucher, it is about the services. Many of our residents with vouchers are supposed to have services that they are not getting, particularly in some parts of the city. And that's something that our agencies have to address because it is creating concern and resentment that I think is making it more difficult for us to get people housed. And it's something that we need our agencies to pay close attention to. With that, I move the print and report for Bill 25-49, the Local Rent Supplement Program Eligibility Amendment Act of 2024, with leave for staff to make technical and conforming changes. All those in favor, please indicate by saying aye. Aye. All those opposed, say nay. And the ayes have it, and the motion passes. That concludes the business on today's agenda. If anyone listening is interested in connecting with the committee or my team or getting involved in the committee work, please visit robertwhiteatlarge.com and be sure to sign up for our newsletter. The business before the committee is concluded. The time is 4:38 p.m. and this additional meeting of the Committee on Housing is adjourned.